Hi everybody, my name is Joe Morvick. I'm the president of the Student Bar Association. For those of you who are students, welcome to the tutor room. This is the room you pass through every day. For those of you who are not here, from the outside community, welcome to our campus. We have a very interesting, very enlightening panel for you today. They're going to introduce themselves. I'll let them get to it. But again, I'd like to take this opportunity to thank everyone for coming to talk about wrongful convictions, particularly in this day and age. It's an important subject. It's something we need to take a look at. It's an important job for both public defenders, criminal defenders in the private sector, and prosecutors to always take into account all of the evidence and make sure they're acting ethically. I'm none of those people. The people to my right have far more experience, far more expertise, and I'll let them introduce themselves. Again, welcome and enjoy.
Hi, thanks everybody for coming. My name is Michael Mushlin and I'm a professor here at the law school. And I'm the first person to speak, but I am not going to speak about wrongful conviction, other than to thank Jeffrey Duskovic and Professor Gershman for their dedication to the cause of the wrongfully convicted. And you're going to spend most of the evening hearing from them. They, like their allies who are fighting the death penalty, which I think this is this struggle they're involved in is, and I know Professor Gershman has been active in his advocacy against the death penalty. I think that's we're making slow but important progress toward making this nation a more just nation. Just today, you may have seen that there's a Pew survey that showed that the majority of Americans now are opposed to the death penalty. So as they succeed, I want to talk on behalf of people who, and as they make progress in fighting the death penalty and fighting the scourge of wrongful conviction, I want to speak on behalf of people who should not be left behind as they make progress, and who I hope will be aided by their efforts. And I'm speaking now, I want to speak to you for a few minutes about people who are not going to be sentenced to death, and people who are not, as Jeffrey was, subject to the horror of a wrongful conviction. I want to talk about the 2.3 million people today in American prisons. 5 years ago, if I had spoken to you, I think I would have shocked you by saying we have the largest prison population in the world. Thankfully, I'm sure everybody now knows that. We have 5% of the people in the world, and 1 out of 4 of the people behind bars on this planet are behind bars within the jurisdiction of the United States. The largest majority of these people haven't been sentenced to death. And the large majority of these people have committed a crime. Let me talk a little bit more about these people. The fastest growing segment of this population, this vast population of 2.3 million people, and that's on any given day. An African-American young born today, an African-American boy today has a 33% chance, if we continue to incarcerate at the level we're incarcerating, of ending up behind bars. The fastest growing segment of this population are women. 12,000 women in 1980 in the United States. If you looked at prisons in the United States in 1980, 12,000 would have been behind bars. Today, as we speak tonight, 182,000 women are behind bars. But the women constitute 8% of the prison population. So I'm here, and it's a horror that they're in, there's so many are in, but they are probably more sympathetic to American audiences than the people I want to talk about. I want to talk about people who are not juvenile, who are not wrongfully convicted. I want to talk about women, but I'm predominantly talking about men. And I'm talking about adult men. That's 92% of our prison population. And these are people, most of whom have committed a crime. So, what do we say about these people? What do we say about these people? Do we say that they're entitled to no decency? Do we say they're entitled to no safety? Do we say they're entitled to no productive activity? Do we say that they're entitled to no help as they re-enter society? Because we can't afford to incarcerate everybody who commits a crime until they die. So the overwhelming majority of these people are going to be released. And so what happens to these people behind bars is of intent, even if they're guilty, of intense interest to us on a number of different levels. One is that many of these people are behind bars for unconscionably long periods of time. The sentences that are meted out to people in New York and around the country are unduly harsh. But in addition to that, the conditions in which they are held don't comport, I think, with our values. Let me just talk briefly about 5 characteristics, and I'll make this fast. 5 characteristics of the American prison system. One is that it's a remote system. For example, in New York, most people who are in prison in this state are from the metropolitan area, but they're held about as far away as you can imagine. Most of them are held very close to the Canadian border in places like Dannemora or Attica. Many of the women are from New York area, are held in Albion, far from their children, far from their families. So to visit these people, or to maintain contacts, which is the best way to provide for rehabilitation, is almost impossible. The difficulty that people have in visiting is really something I wish I had time to talk to you more about. The second aspect, so one is that people are sent to faraway prisons, and what happens in New York happens just about every place in the country. Second thing is that most people are idle in prison. One of the characteristics that I've noticed when I go to a prison is just how quiet it is, how nothing's happening. They'll show you a classroom, but nobody's in it. You'll go to an area where they're supposed to be training for employment, and nobody's there. Let me give you just one example from New York. 40% of New York prisoners don't have a high school degree, but 21% of the teaching positions in prison are vacant. Only 3% are enrolled in any kind of school, and 44% don't get any vocational training. So prisons are remote, prisons are idle, and we have a system in the United States where a large number of people are held in solitary confinement. I guess people know what solitary confinement is. Solitary confinement is a form of punishment. It's a form of really torture, where you're locked into where you're basically buried alive. And most people think where you're locked in yourself for 23 hours a day, by yourself, for day after day, week after week. I met a young man this summer. I had pizza with him, actually. He had just been released he'd been released about a year ago from prison. He was arrested for some burglaries that he had committed when he was a young man, 17 years old, and sentenced to guess how long in prison. He spent 17 years in prison. No one was hurt in his robberies, which isn't to say he didn't commit a crime, which isn't to say he didn't put people in physical fear. But he spent 17 years behind bars. During that time, he had a record which was, he never committed any violence when he was in prison. I just want to give you one example of how solitary works. And his is kind of a typical example. He got someone brought in a cell phone, which is considered to be contraband in New York State prison. And he used the cell phone to call his family. The cell phone was discovered, and he was sentenced to 3 years in solitary confinement for having a cell phone. So, to maintain control of these remote idle places, people are held, many in solitary confinement. In New York State, about 8% of all our prisoners are in solitary confinement. Prisons also aren't safe. There's a tremendous amount of violence. Luckily, thankfully, we've been seeing some indictments for the violence that occurs. And finally, the prisons operate without any oversight. So these are places that are remote. They're places where there's idleness. They're places where there's extensive use of solitary confinement. They're places of violence. And they are places that operate really essentially in a lawless manner without any kind of external oversight. So, I don't mean to depress everybody, but I wanted just to start out, but I'm very glad that I was invited to this, and I'm grateful for the invitation. And I wanted to use it to say, while the focus of tonight is on unjust conviction, and we should obviously not ever have anyone who is innocent ever subjected to imprisonment, no matter how imprisonment is structured. I'm glad I was invited because I think it's important as we struggle against unjust convictions and as we struggle against the death penalty, that we don't lose sight of the people who are going to legitimately should be subjected to a criminal justice system. And my plea is that it is as essential that we have a humane, lawfully operated criminal justice system to function not just for the people who are unjustly convicted, and not just for people who the state is contemplating the death penalty, but that it should function for all Americans, and that it should function for people who have made mistakes in their lives, and that we should have a system that is worthy of our values, and the system we have today doesn't. So I'm thankful that I was given a brief time to address you. So thank you very much.
Well, I feel privileged to have been invited to speak to you on Wrongful Conviction Day. I feel honored to be on the same panel with Professor Michael Mushlin, who I'm sure many of you know is the nation's leading expert on corrections law. His 3-volume treatise is, as they say, the definitive work on prison law and policy. And he speaks and lectures all over the country on prison law, prison reform, and so I thank you, Michael, for what you've done, your contribution to this critical part of our society, which nobody really knows too much about. And I'm privileged to be on the same panel with Jeffrey Diskin, who's just started his career at Pace Law School, and I'll have more to say about that in a second. I thought I'd start off by just going back 93 years to a remark that the great federal judge Learned Hand once made. Anybody, you've all heard of Learned Hand, right? Okay. He was on the Second Circuit Court of Appeals. They called him the 10th Supreme Court Justice. And Learned Hand once said, in the case of the United States against Garson, our procedure has been haunted by the ghost of the innocent man convicted. It's an unreal dream. Innocent people don't get convicted. Only the guilty are convicted, and I'm sure if you brought some prosecutors into this room, some of those prosecutors would say, I've never convicted an innocent man, and I don't know that innocent people get convicted. But we know that's not so. I mean, if you just go to the National Registry of Exonerations, started listing the official exonerations since 1976, they found, as of this morning, and I decided to do it, 1,894 official exonerations. As you go down the list, you'll see 217 exonerations from New York, and as you go down the New York list, you'll see the name Jeffrey Deskovic, who was imprisoned in 1990 and exonerated in 2006. And you'll also see, by the way, the name of William Hoey, H-A-U-G-H-E-Y. He's from Westchester County, and he was exonerated just a few months ago. And he was exonerated because of the work of the Jeffrey Deskovic Foundation for Justice. That's quite a tribute to this young man. And I'm going to guess, you know, if we've got 1,894 official exonerations, you've got to figure that all of these exonerees were able to prove by DNA evidence or by real info that they were innocent. How many hundreds or maybe thousands of young men and women who are sitting in jails all over the country are innocent but don't have the proof to go to a court and don't have the proof to get a prosecutor to take a second look at the case? There's gotta be thousands of innocent people sitting in jails in America today. There's gotta be. You know, we're shaped by our experiences, and I can't relate at all to the horrific, unbelievable experience that Jeffrey Deskovic endured for 16 years. I don't know if anybody can. Sitting in a jail cell for 16 years for a crime you didn't commit. How do you do that? How is that possible? I remember when I talk about how we are shaped by experiences, I want to tell you a story. It's a story that I think is relevant to today's program. I graduated from law school a long time ago, and I was honored to be admitted into the office of the Manhattan District Attorney, Frank Hogan, the legendary district attorney's office, featured in the New York Times Magazine, famous article. It was titled, Hogan's Office is a Ministry of Justice. And I felt that way when I was in the office. I felt that way day to day. It was the greatest experience of my life, professionally. The people in the office were great. I mean, we felt that we were on a mission to do justice. We really did. And I remember coming into the office, my first bureau chief, Melvin Glass. I've dedicated my treatise to him because he taught me almost everything I began to know about what a prosecutor is, what a prosecutor should be doing. Mel Glass started talking to us about a case that he was involved in. And I came to be involved in that case myself a little bit later on. The case is referred to, any place you go, as the Career Girls Murder. Two young women, Janice Wiley, 21 years old. She was the daughter of Philip Wiley, Max Wiley, a novelist, Janice Wiley. Emily Hoffer, 23 years old. They lived a third-floor apartment on East 88th Street, right off in Manhattan, right off Madison Avenue. And on August 28th, 1963, their third roommate came into the apartment. August 28th, by the way, 1963, was the day of the March on Washington and the famous I Have a Dream speech by Martin Luther King, and we remember that date. But when the roommate came into the apartment, she found her two roommates unbelievably slaughtered. with 60 knife wounds. I mean, Emily Hoffert was almost decapitated. Janice Wiley was disemboweled. She was naked with a towel around her. I never knew what the word disemboweled meant as well as when I saw the picture of the scene. And she was sexually assaulted. And the investigation, obviously, hundreds and hundreds of police officers began to search for the killer. And it was called the Career Girls Murder because these two young women were from out of town and they came to New York City for a career. It was one of the most sensational and grisly murder cases in the history. About 8 months after the murder was discovered, the Brooklyn police picked up a young man named George Whitmore, 19 years old, a laborer, high school dropout, African-American young man, very low IQ. And they charged him with raping a woman named Elma Barrera. They showed Miss Barrera one picture, one photograph, and she identified George Whitmore as the rapist. And so they bring George Whitmore into the Brooklyn precinct. And two of the detectives, Joseph DePrima and Edward Bulger, I like those names, DePrima and Bulger. They were big, big, big detectives, tough. They bring Whitmore in and they search him. And in his wallet, they find a picture of a young blonde woman who Bulger decides is Janice Wiley, one of the victims. And obviously he got that picture from her apartment. And so they now proceed to interrogate George Whitmore. They interrogate him for hour after hour after hour. First, he denies having anything to do with the girl, Janice Wiley, Emily Hoffert. He denies the Barrera rape, but they start to question him over and over and over again. What happened in that interrogation room, we really don't know for sure. Whitmore claims they beat him, and they beat him. Cops say, oh no, we just began to question him. The police do. About 10 or 12 hours later, they've got a 61-page signed confession from George Whitmore, a confession that is the evidence that convicted Jeffrey Deskovic, and it's a confession that was going to convict George Whitmore. 61 pages, as you read it, the police said the confessor, Whitmore, provided details that only the killer could know, but that's not true. If you looked at that confession, you'd know that every single detail in there was reported. And actually, some of the details in the confession were wrong. We knew they were wrong, but they were in police reports. And if you were going to read police reports and look for facts in the police reports, you might have found certain facts that would find their way into the confession, and those facts were wrong. But the Brooklyn police had those facts from police reports that were not accurate. Anyway, Whitmore is indicted by the Manhattan DA's office. By the way, we had the death penalty then. But Mel Glass, my bureau chief, and another attorney in the office, Peter Costi, began to look at that confession. And the confession didn't add up. There were certain facts in that confession that just weren't true. I mean, the confession says that George Whitmore, I got off at the Port Authority bus terminal, and they knew he would get it because he lives in Wildwood, New Jersey, and came to New York. And I walked a few blocks, and I wound up at 88th Street and Madison Avenue. I walked a few blocks from the Port Authority, and I wound up at 88th. I guess they didn't even know where the Port Authority was. And so and I walked along the street, and I got into this building through the door on the street that led into the back entrance, the freight entrance. Well, he couldn't have gotten into that door because that door was always locked, and the only way you could open that door was from the inside. And there were other facts in his confession that just didn't add up. He said he found a certain jar of Noxzema in the apartment that he entered. But that wasn't true. That was something that was an inaccurate fact in the confession. But the Brooklyn police saw that in a police report, and that found its way into Whitmore's confession. And as you go through the confession, detail after detail just didn't square with the facts. And we knew that. And so we started having second thoughts. And Frank Hogan persisted, wouldn't dismiss the case yet. And then about a year after the killing, a few months later, a man named Nathan Delaney is arrested and charged with the murder of a junkie. And Nathan Delaney was a junkie himself. And Nathan Delaney says, I'll make a deal with you. If you give me leniency, I'll tell you who killed those girls. And we did. And he told us that on the day of the killing, sometime later in the day, a man named Ricky Robles, R-O-B-L-E-S, came into his apartment. They were friends. Robles had just got out of prison 2 months earlier. And he came into the apartment, soaked in blood, and told them I just iced 2 girls. And he told them some facts about it. He said he needed a fix. He tried to burglarize an apartment, but this girl appeared, a young woman with a towel around her. That was Janice Wiley. And he didn't think anybody was there. And he immediately attacked her sexually. Then Emily Hoffer came into the apartment a little bit later. He bound them both up, back to back. And then when Emily Hoffer said to him, I know what you look like, and I guess Robles freaked out. He got the knives from the kitchen, and he just stabbed and stabbed and stabbed and stabbed and stabbed savagely. And subsequently, we put a listening device in the Delaney apartment. And because now Delaney and his wife, Margie, were cooperating with us, Robles would come to the apartment, and Delaney would, at our instructions, lead Robles on to make incriminating statements, and there were many, many of those incriminating statements recorded. And that was the evidence that would prove Robles' guilt. He's probably still in jail today. In 1988, about 20 years later, he was brought before the parole board. And at that time, for the first time, he admitted to killing those 2 young women. We had a tough time at the trial because the defense, obviously, third-party defense, they're going to put on evidence to show that George Whitmore was the killer. And we were able to show, first of all, that the photograph in Whitmore's pocket, which he claimed always he found in a dump in Wildwood, New Jersey, we were able to prove that it was a photograph of a young woman named Arlene Frank. And she testified. We said, Arlene, is this your picture? Yes, it is. What did you do with this picture? Well, when I was cleaning out my house when I was moving, I put all those pictures and everything else in the garbage bin. And where would that garbage bag go to? Well, it would go to the dump. Where was the dump? In Wildwood, New Jersey. And that's where George Whitmore said he found the picture. And he put it as well. I mean, he knew Arlene Franco, and kind of a sad story how he found the picture. But we were able to corroborate that he found the picture. And I remember when they called Bulger, the detective from Brooklyn, to testify to the Whitmore's confession, and that the confession was reliable. And I remember John Keenan, our homicide chief, who was trying the case, great trial lawyer. He says to Bulger on cross-examination after he testified to Whitmore's confession, he says to Bulger, Whitmore claimed he was innocent, right? And he claimed it. And you thought he was lying, didn't you? Yeah, I thought he was lying. Okay. By the way, when you thought he was lying, did you look at his stomach? Bulger, what's up? Did I look at his stomach? Yeah. Did you look at his stomach when you thought he was lying? I don't know. I thought I looked at his stomach. Well, didn't you tell so-and-so that you could always tell when and I'm going to just say the N-word, is lying? You just have to look at their stomach going in and out, and you know they're lying. Did you ever say that? Well, he's hit pretty hard by that question. I think he's dropping down in his chair a little bit, starting to sweat a little bit. After that, the jury knew who they were dealing with Mr. Bulger. I mean, they indicted. George Whitmore was charged with the 2 rapes, rape of a woman, the murders of the 2 young women, another murder. I mean, the Brooklyn police cleaned it up that night. By the way, if you want to read the Miranda case sometime, some of you might want to read it, maybe even in my class, you'll note, I think it's footnotes 42 and 43 in Miranda. Those footnotes, when they talk about how even innocent people confess, they drop a footnote, and that footnote is to the Whitmore case. Well, I just now want to talk a little bit about your fellow student, my student. I remember about maybe 20 years ago, I started reading articles in the Journal News about a murder case from Peekskill, and it was very, very troubling. The stories were about a young man who was convicted of murdering a classmate named Angel Correa. Angel Correa. She was 17 years old. The young man was 15 years old. And the stories talked about how he was convicted. He spent 16 years in jail. He had been trying to prove his innocence, but the Westchester District Attorney 5, 6, 7 times refused to entertain any of his positions, refused to do any testing because there was an issue of DNA in the case. And the district attorney, Janine Pirro, refused to test and fought all of the applications by this young man, who's now 16 years in jail, Jeffrey Deskovic, pleading to do DNA testing to prove his innocence because there was DNA at the, on this young woman. Now, it's interesting because the prosecutor in the case, his name is George Boland. I always would look at cases prosecuted by George Boland with a special eye. George Boland was one of the most ethically challenged prosecutors, I think, we've had in Westchester County. If you have any cases he prosecuted, look closely at those cases. He prosecuted this case. And there was DNA initially, but he never disclosed that there was DNA evidence. You can get DNA evidence, tested. He never disclosed it. Until sometime, maybe 6 months later, it came out that there was DNA evidence. So he now suborns perjury. After hiding this DNA evidence for 6 months, he now has the medical examiner testify, yes, there was DNA evidence. Did the DNA evidence match Jeffrey Deskovic? No, it didn't. Well, what? And so they come up with this theory that the DNA evidence was from some classmate who had sex with this 17-year-old Angel Correa, consensual sex, which was so preposterous. And they're smearing this young woman. She didn't have any consensual sex with a classmate, but it's a way of trying to explain why the DNA evidence was there. And then there was a hair that was found on the autopsy, a negroid hair. And the prosecutor now explains the presence of that hair. Where did it come from? Well, it came from either the medical examiner himself or one of his staff while they were doing the autopsy. Let's just push forward. Where did this come from? Well, it came from a man who, in 2006, we found out, is presently in state prison for a murder. And it's his hair that DNA that was on Angel Correa. And while Jeffrey Deskovic is languishing in state prison for a crime he didn't commit, the real murderer killed somebody else. And why Janine Pirro wouldn't do the testing? It was so simple. Why she resisted? Jeffrey spent 8 more years in jail. Had she done the testing earlier, it would have proved Jeffrey didn't do it. But she resisted, she fought the habeas corpus petition, she fought everything. Some prosecutors will be willing to do justice and make sure that they haven't convicted an innocent person. Some prosecutors will resist, and this prosecutor did resist. And it's just cruel what happened here. But in any event, Janet DeFiore, the new DA, did the testing. The rest is history. Jeffrey was exonerated, and actually Janet DeFiore established a commission. The prosecutors don't do this very much. Commission to find out what happened. And when the report of the commission showed a lot of people were to blame. Prosecutor, judge, defense attorney, police, for this abomination, perversion of justice. So you've got, and the conviction was based on Jeffrey's confession, just as in the Whitmore case, a false confession. Do innocent people confess? We know that's true today. Yes, innocent people do confess. Jeffrey is a scared 15-year-old young man. At the end, I think they said he was just lying in a fetal position, crying and pleading. It was a horrible, horrible thing to even contemplate what must have gone on there. But anyway, after being exonerated, he went to Mercy College and got a degree. He went to John Jay College of Criminal Justice with a master's degree. He was named by John Jay as one of the top 50 graduates in the last 50 years of John Jay. He lectures to police academies, prosecutors' offices, judges on wrongful convictions. He's written extensively on wrongful convictions. I think that he developed a course at Farley Dickinson University and taught it on causes of wrongful convictions. He was honored by the New Rochelle Chamber of Commerce as the Man of the Year. He was honored by New York 1 for contributions to criminal justice. He's written hundreds of articles. I didn't realize Sports Illustrated also he's interviewed all the time by the media. And I think one of the most remarkable things, of all of the lobbying the legislature in Albany on wrongful conviction legislation, on capital punishment, on prison reform, parole reform, he's managed to use compensation that he received after he was exonerated. I mean, some people will just pocket the money and go on trips around the world. He set up his own Jeffrey Desker Foundation for Justice. And the foundation, as I say, it's exonerated several people. The last being Mr. Howie, here in Westchester County. He was convicted in Putnam County for arson that he never... I remember he wrote me letters saying, I'm innocent, I'm innocent. And, you read those letters, and yeah. What do we do here to prove it? Proving it is hard. So I just want to say, the Journal News wrote an editorial, and they, I can just read it. When Jeffrey was admitted to Pace Law School, and the editorial thanked him for his devotion, his perseverance, his heroism, his courage, in making his life such a meaningful life. And he's ended, we're really proud of you. Good luck, Jeff. The world of American jurisprudence is lucky to have you. And I think Pace Law School is so lucky to have Jeffrey with us also. And so it gives me tremendous pleasure and honor to introduce Jeffrey.
Thank you very much. It's been a long road. 16 years in prison, and then it was 10 years of advocacy afterwards. And to finally make maybe my last stop, in terms of just finally here at law school. It's didn't quite think I'd make it here. I'm really happy to be here. I'm really grateful to have been given the opportunity to further my education and to take my advocacy work to the next level and to continue to pay it forward as I've been doing to the best of my ability regarding things really as a trust, as a responsibility, as an obligation, something that involves sacrifice, that's a burden, but that also in many ways is meaningful. It makes sense of everything, and it's needed. So I want to thank everybody for coming out, because, I mean, it's kind of like the metaphor. I mean, if the tree falls in the forest but there's nobody there, does it make a noise? So today's Wrongful Conviction Day, and we have the panel, and if there's no audience, on Wrongful Conviction Day, then is there really a Wrongful Conviction Day event? But instead of being in that scenario, I mean, we actually have a really great audience. So I want to thank everybody who came out, and all the people who helped to make this possible. I mean, all the people who worked behind the scenes, who maybe remain nameless, but who played important roles. Any one of which the absence of, very well could have translated into not having the event tonight. In 1989, a classmate of mine was found murdered and raped. Peekskill was a small city here in Westchester County with a population of approximately 25,000 people. Murders were very rare. So when this murder happened, it understandably created an atmosphere of fear, rumor, paranoia. Parents were concerned with their own safety as well as the safety of their children. In high school, I was quiet. I was to myself. I didn't participate in very many organized sports. This made me seem strange to the kids in the school. In the course of the police investigation, the police interviewed many students from the school. Some of those students told the police that they might want to talk to me because I seemed strange to them. This is what the police said initially attracted them to me. The other factor which they said attracted them to me was that they said that I was overly upset at the victim having been murdered. Yet there were mental health facilities set up all throughout the city of Peekskill to help people process what had happened, again keeping in mind that murders were very rare. So for about 6 weeks, the police played this cat and mouse game with me, in which half the time they would talk to me as if I was a suspect, and the other half the time they would talk to me as if they needed my help to solve the crime. They would say things like, well, the kids won't talk freely around us, but they will around you. Let us know if you hear any rumors. Stop in from time to time. They would ask me opinion questions and then congratulate me on my opinions being correct. They made me feel important. My fantasy childhood career pre-teenage years was to be a police officer. So this unexpected early opportunity to do this quasi-police work, along with my age being 16, went a long way to explaining how they were able to pull this absurd fiction over my head, that a 16-year-old could possibly be of any assistance in a homicide investigation. I also came from a single parent household. My father was really never involved in my life, and so one of the police techniques was the good cop, bad cop, also known as Mutt and Jeff, ironically. And the officer who was pretending to be my friend, I began to look up to him as a positive male role model, so this was another psychological factor at work. So after about 6 weeks of this, the police told me that there was some new information that had come into the police file, and they wanted to share that with me, and that this would put me in a better position to help them out. So a help us to help you to help us type of logic was employed. But of course, before they could share that extra piece of information with me, I would first have to take and pass a polygraph. And so the next day, rather than report to the school, I instead went to the police station for the polygraph. It was, as I just mentioned, a school day. So that meant that my mother and grandmother thought that I was in school, and therefore they did not realize that anything was wrong, and so they didn't call around looking for me. I thought that the polygraph was going to happen at the Peekskill Police Headquarters, as I had heard through rumor that other people that the police had interviewed were polygraphed at. But instead, the police drove me across county lines. From here in Westchester County, they drove me to Brewster, which was in Putnam County, so about 40 minutes away. And the reason why that's important is that that meant I was no longer able to leave on my own. I was instead dependent upon the police. They put me in a small room. I didn't have an attorney present. I wasn't given anything to eat the entire time I was there. There were 3 officers there from Peekskill, but then there was also the polygraphist, who was a Putnam County Sheriff's investigator, Daniel Stevens, who was dressed as a civilian and he was pretending not to be a cop. So I never knew that he was an officer, and he never gave me the Miranda warnings. So he gave me countless cups of coffee, and it's fairly clear in hindsight that the purpose of the coffee was to get me nervous, so that when he eventually employed his polygraph, he was setting it up to rig the test results so that that could be used as a further psychological tool. So after his coffee routine, he must have given me 6 or 7 cups of coffee. He became like a virtual coffee dispenser. When he finished with that, he then strapped me into the polygraph machine. And that's when he launched into his third-degree tactics. So he invaded my personal space. He raised his voice at me. He kept asking me the same questions over and over again. As each hour passed, my fear increased in proportion to the time. Towards the end of the interrogation, I guess he was exasperated by this point. He said to me, "What do you mean you didn't do it? You just told me through the test results that you did. We just want you to verbally confirm it." So when he said that to me, it really shot my fear through the roof. It was at that point that the officer who was pretending to be my friend, he came in the room and told me that the other officers were going to harm me, but that he was holding them off, but could not do so indefinitely. "You have to help yourself here, you understand." Considering that I had maintained my innocence for the previous 6.5 to 7 hours, it was clear what they meant by that. They wanted me to confess. When he added that if I did as I wanted, not only would they stop what they were doing, but that I could go home afterwards, that I was not going to be arrested. Being young, naive, frightened, 16 years old, not thinking about the long-term implications, instead only being concerned with my safety in the moment. I was in fear of my life, the way that they were. I wasn't used to being around adult males, first of all, and secondly, they were conducting themselves in a really frightening fashion, and the fact loomed large in my mind that nobody knew where I was, and that I didn't know where I was. So being emotionally and psychologically overwhelmed and in fear of my life. And then also there was the push-pull dynamic, because on one hand, he's introduced the possibility of harm, and then on the other hand, he's thrown me this false life preserver. So I took the out, which he offered, and I made up a story based on information which they had given me in the course of their interrogation. Both that day as well as in the 6 weeks prior to that, and as well as items that had been in the newspaper. By the police officer's own testimony, by the end of the interrogation, I was on the floor in a fetal position. I was crying uncontrollably. At that point, afterwards, they saw fit to finally give me something to eat. Needless to say, I was arrested. I was charged with a murder and rape. So before I went to trial, the results of a DNA test came in from the FBI lab showing that semen found in the victim didn't match. But rather than acknowledge they made a mistake, they instead continued to prosecute full speed ahead. In order to explain away the exculpatory DNA test result, the prosecutor suborned perjury on the part of the medical examiner. When an autopsy is done, there's audio and written notes which are taken contemporaneously as the findings are made as a way of ensuring authenticity. So it was only 6 months after doing this initial autopsy, and only in response to the DNA not matching me, that suddenly, for the first time, the medical examiner claimed that he had medical evidence showing that the victim was a 15-year-old immigrant from Colombia who'd been in the country about 1.5 years, leading a really sheltered life. She never went outside unless she was with her older sister or with her parents. So he claimed he found medical evidence to basically say that she was sleeping around, which is what opened the door for the prosecutor to argue that it didn't matter that the DNA didn't come from me, because it could have come from his consensual sex, that she had close enough to the murder and rape so as to explain away the DNA. Taking it a step further, the prosecutor also mentioned another youth by name, a classmate that he claimed had likely had sex with the victim. But it was an improper argument because he didn't first lay the proper evidentiary foundation, meaning that he didn't have a DNA test performed first in order to prove that. He didn't even call him as a witness to give verbal testimony to that effect. He simply made the unsupported argument to the jury. And on a similar way, when the hairs in the body didn't match, he also, again, resorted to arguing by inference without first establishing a proper foundation, claiming that it was must have come from the medical examiner's assistant. So I later learned, years later after I was exonerated, that when the hair expert learned that the prosecutor was going with that explanation, he asked for the hair samples to actually be turned over so that he could do the comparison, but that the prosecutor refused to turn over the samples. At the same time, the public defender that I had was terrible. Here's some of the ways in which he failed me. He never interviewed nor called as a witness my alibi. I was actually playing wiffle ball when the crime happened. He never explained to the jury the significance of the DNA not matching me. He never used the DNA to argue that this so-called confession was coerced and false. When it was time to cross-examine the medical examiner, he stood up in open court and, as if he and the medical examiner were great friends from way back in the day, said to him with a big smile on his face, he said, "You're going to be pleased to know that I don't have a single question for you." When we hadn't decided if I was going to go with a bench trial, which is decided by a judge or a jury, my attorney came to me one day and said to me that the judge came to him off the record and told him to pick a jury because he didn't want to be responsible for finding me not guilty. My lawyer was supposed to put that on the record and ask the judge to recuse himself because a statement like that shows bias and also suggests that the judge may be feeling some public pressure because the case was a high-profile case, and every time I made a court appearance, it was a big media item, and virtually all the coverage was written from a guilt presumptive oriented perspective. My lawyer very rarely met with me. Whenever he did meet with me and I tried to explain to him that I was innocent and what happened in the interrogation room, he was always shutting me up. I remember one time that sticks out in my mind, he told me that he didn't care if I was guilty or innocent. The interrogation was not videotaped and it wasn't audio taped and there was no signed confession, and so it was just the cop's word, and so they conveniently left out the two illegal acts which they had engaged in, which was the threat and the false promise. So I wanted to testify at the pre-trial hearing and testify to those facts, but my trial lawyer wouldn't allow me to. He told me that he hadn't decided if I was going to testify at the trial or not, and he didn't want to have me on the record as to what happened in the interrogation room in the event that I did take the stand, telling me that the prosecutor could use the prior testimony to cross-examine me with and try to make it look as if I was lying, even if I wasn't. But it really didn't make too much sense what he was saying, because first of all, if the judge had believed me, then the statements would have been suppressed as being involuntary, and lacking that, there was no other evidence, and so the case really would have been dismissed. So there was really not really anything to lose. Then secondly, if it really went that badly, I mean, I didn't have to take the stand at the trial, and if I didn't, then the prior testimony would not have been able to be used. But then when I got to the trial, he wouldn't allow me to testify there either. He told me that it wasn't his job to prove that I was innocent. It was up to the prosecution to prove that I was guilty. That's a legal maxim. I expect that we learn that in the classes here, but that's a really naive way of looking at things. That's not the way it works in the real world. In reality, despite any verbiage to the contrary, if you're charged with a crime that you didn't commit, you have to do everything in your power to try to prove that you're innocent, or else you run the risk of possibly being wrongfully convicted. So his second rationale for not allowing me to testify at the trial is he told me that his personal one-loss record was significantly better when his clients didn't testify as compared to when they did. I'm sure that's true. Probably most of his clients had a pre-existing criminal record. If they took the stand, they would be allowed to be cross-examined on that issue under Sandoval. But that didn't apply to me because I had never been arrested for anything. I didn't have a pre-existing record. But my lawyer really should have never represented me from the beginning because of the conflict of interest, and that this other youth that the prosecution was making this false claim about, claiming that the victim had sex with him, he was represented not only by another member of Westchester County Legal Aid, but specifically by the lawyer who was supposed to be advising him on my case. So that conflict of interest prevented the defense from seeking DNA testing or calling him as a witness in the furtherance of exploding the whole consensual sex theory. Add it all up, I guess it's not that surprising that the jury found me guilty. I'll never forget the day that I was found guilty, because to my way of thinking, up until that point in time at least, only guilty people were convicted. Yet they said what they did, and I was taken into custody. On the day of the sentencing, I begged the judge to overturn the verdict because I was innocent, and I referenced the DNA to support my contention. He actually told me on the record, maybe you are innocent, conceding that there was a doubt. Well, how could there not have been a doubt? The DNA didn't match me. Yet, instead of stepping up for justice and exercising his discretion by overturning the conviction, which he could have done by reversing any number of rulings that he made against me, he instead took the easy, politically expedient way out, which was to sentence me to a term of imprisonment of 15 to life. So I want to show you some slides here so we can kind of talk, understand more what we're talking about here. So this slide right here, this is my mugshot. This is what I looked like when I was arrested. I wasn't the man you see now. This is what I looked like in the courtroom when it was announced that there was a jury verdict, but it hadn't as yet been read. And obviously, I'm praying for things to go the right way, which they didn't. This is what I looked like when I was sentenced. This is a early picture of me in prison, in a men's maximum security prison. Stop there. I'd like to share with you a little bit about my prison experience. I still remember the first day. I remember still being in handcuffs and having a chain on my waist and having my legs fastened together and being fastened on the legs of the prisoner on the bus next to me. I remember how large the prison walls loomed and how menacing the barbed wire appeared. I don't mind sharing with you that at 17 years of age, weighing about 150 pounds, I mean, we can see what we're talking about here. I was really, going into a men's maximum security prison, I was really frightened. As I walked down the cell gallery, I saw a lot of prisoners there whose arms were as big as my legs. Didn't take a lot of figuring out on my part to realize that if any of them decided to assault me, that at that age and that build, what was I going to do against a fully formed adult that was guilty of committing a very serious violent crime? The guards themselves were obstacles. To be sure, some were professional and did their job. Yet there were others who came into the prison and displaced their frustrations from their personal life onto the prisoners. Then there were other guards who just wanted to do their 8 hours and go home, and they didn't care what happened while they were there. That might sound like an ideal attitude that you'd want a guard to have if you had to be incarcerated, but it didn't actually work out that way in real life, because it wouldn't be unusual for them to literally look the other way and walk in the opposite direction when violence was occurring, so as to be able to avoid having to break anything up or file paperwork afterwards. Then there were other guards who even their peers hated. The manner in which they conducted themselves on a day-to-day basis made it likely that prisoner to staff violence could take place that would draw them in. But yet nobody ever bothered to reel them in. Not their co-workers nor the people who supposedly were there to supervise them. In the facility in which I spent 13 and a half of the 16 years, Elmira, it was particularly violent there. There were 3 or 4 stabbings or cuttings every day. There was plenty of violence that didn't involve weapons, and there was no shortage of gang activities. Taken cumulatively, there was a general atmosphere of violence and adrenaline that permeated the air. There was a system of maintaining order in a prison known as keep lock, which involved a variety of sanctions being imposed on the prisoners if they were found guilty of having broken a prison rule. Some of those sanctions included, but was not limited to, and this would all happen simultaneously. It's not that the judge would pick from the menu. This all would happen. They would keep you in the cell for 23 hours a day. They would send you less food. Sometimes the food would be 3 or 4 days old. You could shower twice one week and 3 times the next, rather than being able to shower daily as the rest of the population. Their idea of complying with the court-mandated 1 hour a day recreation consisted of putting the prisoners in a small caged area with maybe a pull-up bar in it, if you were lucky. You could not use the phone while you were on that status. There were several times in the course of my incarceration that I was assaulted, one time in which I nearly lost my life. I got hit multiple times on the side of my head with a 10-pound weight plate by this prisoner who, I guess in his mind, he was carrying out some vigilante justice, because I wasn't just there for a murder. I mean, that would have been fine, but instead I was there for a murder and a rape. So, because in each of those incidences, I did the best that I could in terms of physically fighting back, and that resulted in all of those sanctions being applied to me. So it wasn't just that I had to deal with the physicality of being assaulted, but then to the prison's way of thinking, since I was fighting back, and that meant that I was doing just that, right? I was fighting. I remember when I was originally incarcerated, you know, I tried to minimize the loss that I was experiencing. So I got a GED, I completed the associates, and I got a further year of schooling towards the bachelor's, but then even that silver lining was taken from me, because in 1995, George Pataki became the governor of New York, and he decided it would be a good idea to cut the funding of college education for prisoners, which was a terrible thing, because, I mean, the recidivism rate was extremely low for anyone with a college degree, broadening horizons and equipping for gainful employment. When that happened, I started taking a lot of vocational trades, but although I amassed many certificates, it's better on paper than in reality, because the curriculum was obsolete maybe 5 years prior to my stepping foot into the shop. So to give a concrete example, I mean, I finished the plumbing class, I got 6 certificates there, but virtually all of the training was in metal pipe, and you know, the piping today is mostly copper and PVC, so the training was really largely useless, and the instructors were really there just to get a paycheck, not so much to actually do any real teaching and instructing. When I was originally wrongfully incarcerated, my mother used to make the 4-hour trip from Peekskill to Elmira. But as the long travel, the years of traveling, kind of wore on her, and things tightened up financially, and she developed some problems with her feet and her back, and so eventually I was lucky if I saw her once every 6 months. My brother is 3.5 years younger than me, and he was also impacted by my wrongful conviction. So the kids in the school, on the school bus, would tell him that his brother was a rapist, and they would say other nasty things, and they would try to hit him, and they would try to stab him with pencils. I guess being unable to get to me, he was the next best thing. In 1996, the prison authorities told me that they received information from the hospital. They said my grandmother was extremely sick and was not going to make it, and so they wanted to know, did I want to wait for her to pass away and then go to the service, or did I want to skip the service and go see her in the hospital and get in a coma? I didn't quite understand why I had to pick, because it would have really killed them to let me go to both. No, by that point I was already in prison for about 6 years. I'd lost a few appeals, and overwhelming majority of my extended family had not come to see me, and I knew good and well they were never going to come to see me so long as I was there in prison. And considering that I was doing a life sentence, this funeral represented the last clear opportunity I had to visit with any of them. So it was a heck of a conundrum to be in. At the end, I decided I would go see her while she was in the hospital, yet in the coma. I forgone the funeral. I've always gotten motion sickness, and so one of the ways you protect yourself from getting sick is eat before you begin the journey. We left Elmira for Peekskill early in the morning prior to the population having been served breakfast. But the guards who had been given funds with which to purchase food items for themselves, they treated themselves to a full breakfast while I was simply given a cup of coffee. So as a result of that, I got really sick, and I was on the verge of vomiting, and they had to stop the car several times. But because I had very little in my stomach, nothing came out, which I guess was kind of a good thing, because considering I had on handcuffs and a chain around my waist, so I couldn't move my hands, and they were not willing to loosen the manacles even a little bit, even though there were 2 officers there, and they each had sidearms, and I'm pretty sure I posed no threat to them in that condition. They weren't willing to loosen anything, and so being barely able to move my hands, had I gotten any vomit on my clothes or my face, I wouldn't have been able to get it off anyway. When we arrived at the hospital, they parked the vehicle as far away from the hospital doors as possible so as to be able to parade me through the parking lot. Again, keeping in mind that I had on handcuffs, I had a chain around my waist, and I had the legs fastened together. I remember there was a nursing attendant on duty, and she did a double take at the sight of me, and there was a young girl running around playing, could have been no more than 5 or 6 years old, and the mother grabbed the child and brought her close to her, as, you know, to safeguard her from me, as if I was some kind of a violent animal that was going to commit a spontaneous act of violence right there on the spot. Definitely a humiliating situation. When it was time to go, the guards came in the room where I was with my grandmother, and they informed me that my hour was up, and I looked up at the clock and I saw that in fact it had only been 45 minutes, but they insisted it was an hour, and they forced me to leave. This time I was given something to eat. However, it was a hot day, it was sunny, and the parking space where the car had been resting, it lent itself to the sunlight beaming through the windshield, and so by now the car had become quite hot. The guards turned on the air conditioning in the car, but there was plexiglass fully separating the back of the car from the front, and so none of it reached me, and they weren't willing to lower the windows even a fraction of an inch. So all told, I went through that hell for about 8 hours in order to visit with my grandmother for less than 1. As my prison sentence minimum grew near to being over, the prison officials told me that if I wanted to have any chance at all of making parole, which was already a slimmer than slim possibility as it was, that I would have to take and complete the sex offender training program. The problem with that program, however, was that there was a guilt admission requirement tied to it. Everybody in the program would be expected to admit guilt, not just to the instructors, but to the other prisoners in the program. Simply saying that one was guilty wouldn't cut it. They wanted all the details. A verbal rendition wasn't enough. They wanted it all to be in writing. A failure to complete any element of that would result in being kicked out of the program, with the prisoner being deemed to have refused to complete the program, kind of borrowing from the rationale of a 12-step AA program. If you can't admit you have a problem, there's no way to progress. But being so unflinching and rigid and unwilling to factor in the reality of wrongful conviction. Now at that point, I was looking at parole as a potential means of regaining my freedom, and I clearly wanted to do that prior to anyone else in my family passing away. So it put me in a really difficult position. In the end, I think I made the best decision I ever really did in my life. I decided that I was not going to take that program. So when I went to the parole board, I knew that they were in the habit of rubber stamp denying applications, even from meritorious applicants, people who could demonstrate that they had rehabilitated themselves and that they didn't pose a threat to society, and that if released, they would live and remain at liberty without breaking the law. So knowing that they were in the habit of doing these rubber stamp denials, I tried to protect myself from having that happen to me. And so I kept raising the issue of my innocence and referencing the DNA, but they weren't willing to even entertain the mere possibility that I was innocent, not even as a contextual factor that to then evaluate the rest of my application. So when I got to the end of the interview, one of the commissioners asked me a question about an aggression replacement training program that I had taken, and I was able to give the answer, demonstrating I learned the material in the workshop. And that's when a different commissioner piped up and said, "Well, that's good, Mr. Deskovic, because you're going to need those skills once you return back to society. Good luck." The procedure is that they don't inform you of the decision on the spot. Instead, it's mailed via institutional mail 3 days later. So considering how that interview ended, I actually walked around the prison for the next 3 days thinking that I had somehow defied the odds and that I would be going home. When I got the decision in the mail, it noted my educational accomplishments, it noted my disciplinary record, it noted that I had some letters of support, that I even had a prison employee recommending that I be paroled, but that nonetheless I had been convicted of a brutal and senseless crime, and as they saw it, to release me would somehow to be deprecated seriousness. They ordered me to appear in front of them 2 years later. So considering that I knew many prisoners there who were working on years 25 and 30 off of a 15 to life sentence in which they go to the parole board, be denied, reappear 2 years later, be denied again, and have that cycle continue in a seemingly never-ending cycle of perpetuity, I felt fairly confident at that point that I was going to die in prison for a crime that I didn't commit. So while all that was happening and much more I'm passing over, I was simultaneously appealing my case throughout the court system. I went to the appellate division, the first court one must go to, where my arguments were my innocence wrapped around the legal arguments. There was legally insufficient evidence, that the prosecutor hadn't proven guilt beyond a reasonable doubt, and that the verdict was against the weight of the evidence. And my Fifth Amendment rights were being violated was another issue. And then there were 6 other issues of law that are not really relevant to this discussion. The appellate division ruled, even keeping in mind that they didn't know about the threat and false promise, but even just taking the rest of the circumstances, no shortage of red flags there. They ruled that that I was not in custody, that the statements were voluntary, and they should not be suppressed. And then they ruled that there was overwhelming evidence of guilt, which I really don't understand that ruling even to this day, because the DNA was in my favor. They ruled against me 5-0. I never again received a substantive decision throughout these next 6 appeals that I'm going to walk you through. My lawyer moved to re-argue the case in front of them, arguing that their decision was running contrary to the facts of the law, but the re-argument motion was denied. Now I've lost twice. I applied to the Court of Appeals with a procedure. You have to get permission first before they'll agree to allow you to argue the case directly and give a substantive ruling. So they declined to give me permission to appeal to them. They said that there was no merit in law to justify reviewing my case, and so they were not going to review it. Now that's 3 losses. I lost in federal court. I lost the habeas corpus petition, which is when the state prisoner is arguing that his or her conviction is running contrary to the United States Constitution. Again, my primary issues were my innocence based on the DNA and my Fifth Amendment rights. But I lost there because there was controversy in the federal court system. 1 year prior to that, in 1996, Congress had passed, and President Clinton had signed into law the Anti-Terrorism Effective Death Penalty Act, which in relevant parts stated that all state prisoners would have 1 year to file in federal court after being denied by their state's highest court. So the confusion in the court system revolved around how would this new law apply to cases already in the system. And different jurisdictions were answering the question differently. And so my attorney asked the court clerk for clarification. Would it be enough that my petition simply be postmarked on the due date, or did it instead have to be physically filed in the building on the due date? The court clerk told my attorney that it was enough that the petition be postmarked. But unfortunately, that information turned out to be inaccurate, and as a result of that, my petition arrived 4 days too late. Former Westchester County District Attorney, who now has a pair of judge shows on television, Janine Pirro, her office took the position that those 4 days were somehow prejudicial to the people, and therefore the court should simply rule that I was late and not get to my issues. And that's what the court did. That meant that I was time barred, which meant that I was no longer allowed to argue my issues directly. I was instead relegated to arguing that the procedural ruling against me was inaccurate in order to try to have that reversed, to then have my case go back down to the lower federal court, to then get a substantive ruling on the merits. And so we applied for permission to appeal to the Federal Court of Appeals. on the narrow issue of being time-barred. So we were given permission, and my lawyer advanced 3 arguments as to why the procedural ruling should be overturned. One of them was that this was an error, this was a lateness not caused by me or by my lawyer, but by the court clerk. I mean, all this fancy legal doctrines aside, I mean, that seems like a reasonable enough argument to me. Secondly, she argued that this was to uphold such a ruling would cause a miscarriage of justice to continue, which in a way kind of backdoors the innocence argument and the DNA back into the picture. And thirdly, that overturning the procedural ruling would open the door to more sophisticated DNA testing of the type which will go on to clear me 8 years later. Once again, the district attorney opposed, and the 2 judges on the circuit that heard my argument, Judge Rosemary Pooler and future U.S. Supreme Court Justice Sonia Sotomayor, upheld that ruling. We then moved to re-argue it in front of those same 2 judges, requesting that all the judges on the circuit hear the case and issue a ruling en banc. But the re-argument motion was denied, which meant we had 1 court left to go to, the U.S. Supreme Court, which nationally hears between 2 to 5% of the total number of issues that come in front of it. Factored into that paltry figure is a certain amount of civil litigation. So we knew going in that the odds of them agreeing to hear my case, despite compelling reasons of justice as to why they should do so, were slim. Having no other court left to go to, we had no choice but to forge ahead. I was not able to overcome the odds. As expected, the United States Supreme Court declined to give me permission to appeal to them. That marked the end of my appeals and the end of legal representation. That was in 2001. The path, therefore, at that stage would be that I would first have to obtain an attorney for free, for I had no money with which to hire one. Hope that I could find an investigator who would also work pro bono, and then hope that in tandem they could somehow find some previously unknown evidence of innocence, without which the court would no longer be willing to hear from me since my appeals were exhausted. So for the next 4 years, if you want to be artsy with words, my legal work consisted of writing SOS-type letters to anyone and everyone I could possibly think of who could help me, either directly or indirectly. I mean, if I could come up with a chain of events that somebody could set in motion which would ultimately result in my getting the legal representation and go from there. If I took the shot, I wrote the letter, I never presumed that anyone would understand how they could help me. I laid it all out clear. First sentence, I'm innocent. Second sentence, DNA proves this, and then this is how you can help me. This is why I'm writing you. So I wrote those type of letters for 4 years, very rarely hearing back from anybody. I wrote large law firms because I read that such firms often have a pro bono section in it. Very rarely heard back from them. When I would hear back, they tell me they didn't have any time to take my case for free. Although they never ended their letter, not a single one of those firms, they never ended their letter to me without making sure that I knew how much money they wanted should I somehow be able to scrape it together. Reading between the lines, they were really saying if I had the money, then they would have the time. Then they would always end by saying good luck, as if I'd be okay despite their non-intervention. I wrote churches and other faith-based organizations reasoning that their belief in God, in whatever form or faith that might take, would cause them to be in favor of justice and against injustice, and by extension, in my behalf. Perhaps one of their parishioners was an attorney or an investigator, they could somehow prevail upon this person to take my case. Or on the alternative, maybe they'd be willing to raise money so I could hire the necessary legal professionals. Except that I never heard back from any of them. I wrote reporters, especially those who had written on various wrongful conviction issues or topics or cases, reasoning that their general familiarity with the subject matter would put them in better position to understand what I was saying. Maybe I could get their interest and they would dig around and write an article or two, and so in that way my case could come to the attention of the necessary legal help that I needed, and I could wind up with representation as I had read it happen in a few other cases, except that I never heard back from any of them. I wrote nonprofit organizations that do successfully free wrongfully convicted people. But the problem I ran into there was that the amount of resources that were available, meaning the number of cases they could work on, as compared to the amount of applicants, there was a big disparity. And so in the eyes of the case evaluators, I was unable to beat out the competition in that cruel contest. In the end, I wound up with some help from an investigator. I wrote a book author in care of the publishing company, and instead of the intermediary sending it to the book author, they instead sent it to this investigator. She worked out of Colorado and Maine, and she said to me, "You're too far away for me to work on your case, but I'll help you network." And so she brainstormed with me, she gave me ideas, and she attempted to get people to take my case. One of the ideas she had proved to be the winning idea. So she told me to write the Innocence Project again. I originally wrote them back in 92, 93, when DNA was accepted, it was used in courts, but it wasn't as advanced. And so after considering my case for about a year, the Innocence Project before, they had turned it down because they had never before saw a case in which there was an exclusion and yet a conviction had resulted. So their typical paradigm of how they were working on cases consisted of obtaining DNA test results and then using the test results, putting that in a post-conviction motion, using the legal theory of its newly discovered evidence. That wasn't available to do in my case because the DNA would not have been newly discovered because it was already known at the time of the trial. So they told me no. So fast forwarding now, I'm in 2006, the investigator told me that the prior denial was irrelevant, and so I should just write them anyway. So I did it. I did it just to do it. I really didn't want to do it, but you know, options were few. Then I forgot about it. I looked for other ways of obtaining legal representation, none of which were successful. So I didn't. So while I waited that 6 months, the investigator also had recruited several respected legal entities to lobby the Innocence Project from outside the organization to persuade them to take my case, and she was lobbying them also. And then I also had the fortune that one of the case intake workers, who was not a lawyer, Maggie Taylor, every time my case was rejected by the lawyers, who once again didn't want to go forward because of the presence of the pre-existing DNA exclusion, she would go back to the drawing board and come up with a new theory under which the DNA could be used to come up with some newly discovered evidence. So on the third attempt, using the idea, one of the ideas that I had suggested to her, the DNA data bank, she got her way, and the Innocence Project agreed to represent me. So that was the first most significant event out of 3 that really turned all this around. The second thing was that Pirro left office, and her successor, Janet DeFiore, she had really been in office for about maybe a little bit less than a year and a half, and she wasn't that well established there. And I think that Barry Scheck was really the bigger public figure than what she was at that point. And she decided to allow me to have further testing, which Pirro would not. So that was the second most significant event. And the third was that we were hoping that the actual perpetrator would have committed an unrelated crime and then gotten caught for that, which would have resulted in his DNA being in the database on the hope that it would match. So they took the crime scene DNA evidence, which already didn't match me, and they ran it through the DNA data bank. And it matched the actual perp because, as was mentioned previously by Professor Gershman, the actual criminal committed an unrelated murder 3.5 years later, that of Patricia Morrison, who was a school teacher in Peekskill who had several sons. So on September 20th, 2006, the conviction was overturned and I was released. I reported back to court November 2nd, 2006, at which point all the charges against me were dismissed on the grounds of actual innocence. So it was at that point that I was free to then try to somehow rebuild my life as best as I could. It's very difficult to rebuild one's life after going through a traumatic experience such as being wrongfully convicted, and particularly one that those include post-traumatic stress disorder, panic attacks, anxiety, which are related to that. This feeling of moving at a slower speed, of feeling of having been frozen in time, this altered personality, fear on seeing law enforcement. Those are all issues that I had to deal with. There's social stigma. Yes, you were in prison for 16 years wrongfully, yes, but you were in prison for 16 years though. How much of that rubbed off on you? Is it safe to have you around? I was asked to leave different places. I remember I stayed a couple nights at the school rectory, and one of the cleaning ladies told the priest to kick me out because she didn't feel safe to have me around. And the priest asked, well, did he say anything to you? No, but I think when people are in prison, it affects them mentally, and so I don't feel safe. So I was kicked out for that. I remember there was a woman who agreed to give me some pro bono tutoring when it came to computer literacy, and she mentioned it conversationally because she couldn't believe what happened to me, and she thought that she wanted to share this with a conversation with people. So one of her male friends, I guess in his mind, he was trying to give her some good advice and just look out for her and look out for her safety, and he made sure to give her some safety tips, not to go and make sure that she met with me in a public place in the library, and by the way, how do you know he was innocent? Were you there? So I know that's an aspect. That's an aspect of this. But wrongful conviction day is, much more. It's much more than me. I'm but one example. So, I was frustrated. When I was in prison, I was frustrated because I would always see when somebody was exonerated, they get that initial hit of publicity, and then they would disappear after that. And I was always frustrated, why don't you keep it going? Why don't you keep making media appearances? Why don't you try to bring public attention to this problem? Open this thing up a little bit for the rest of us. So when I unexpectedly found myself free, I drafted myself. I said to him, what, you used to criticize people, but now you're out here, what are you going to do? Are you going to be any better? And so I became an advocate. When I was released, I gave an off-the-cuff 2.5-hour presentation at the press conference. Everything I ever wanted to say, but could never quite get anybody to hear. It all came out, and just as I thought I was finishing, another topic would come out, and then the words would flow, and before it was said and done, it was several hours. And at that moment, I realized, I could be a part of the Innocence Movement without necessarily being a lawyer, and so I embarked on an advocacy career from speaking to writing to trading privacy for awareness to meeting elected officials to, if it was advocacy related, I did it, and it's cathartic, it's meaningful. I really consider that I'm in the world to do this type of work. This is how it makes sense out of what happened, and I take that silver lining, I take some solace out of that. And so that brings up really for discussion this slide right here. So this is what I looked like when I was released. Okay, so we're gonna do a really dramatic. So we got this before, okay, and we have after. Okay, and so after being an individual advocate for about 5 years, I won some of the lawsuits. So I decided that I would take some of the money and open the organization to free other people. And so this is the slide right here. When I opened the organization right here, we see other exonerated men here. Fernando Bermudez, who did 18 years, and Shabar Collins, who did 16, and Raymond Santana in the back over here from the Central Park 5 infamy. And so in our 4 years history, we were able to exonerate several people, as Professor Gershman mentioned. Our first exoneree was William Lopez, who had served 23.5 years in prison prior to us exonerating him collaboratively with his pre-existing legal team. And so this was the picture right here, the press conference. This was Bill. So that was our first exoneration. And then we had our second exoneration a few months ago. Professor Gershman mentioned William Hawley. So this is William Hawley right here. It's a staff attorney and a fire expert. This is in the office. And, you know, that is right there. So freeing those two people definitely was kind of a otherworldly experience, kind of a surreal thing. But how many people are wrongfully convicted? Is my case really an isolated thing? Well, last year, 149 people were exonerated nationally. And the year before that, 139 were. And in 2012 and 2013, 91 people were exonerated in each one of those years. So people ask sometimes, well, what percentage of prisoners do I think are wrongfully convicted? And so here's my answer. So when I think about the number of people that I just mentioned to you that were exonerated, when I think about how when there's a regime change in the DA's office, looking at Brooklyn as a quick example, and where the challenge would be the 23-year incumbent, largely on the wrongful conviction issues, and having a proactive conviction review unit, and 21 people being exonerated in a little bit more than 2 years. And, you know, certainly that can't be the only place where all these wrongful convictions are being sat on by incumbents and staff. And so when I think about every time there's a rogue police officer, I mean, here in Brooklyn, Detective Scarcella, who he had this informant who was a drug addict and a prostitute. And she had a knack of always being in the right place at the right time, serving as the sole eyewitness in no fewer than 6 different homicides. And then his confession case is coming under scrutiny. Seemingly everybody confesses to him and says, okay, you got me. So depending on which news account you want to read, 40, 50, 70 cases of his under scrutiny. And that's just one rogue law enforcement officer. How many more rogue law enforcement officers are there? How many rogue forensic scientists are there? Think about all the different junk sciences that have contributed to wrongful convictions, things that used to pass for evidence in the courtroom. Things like tire tracks and bite marks and footprints and fingerprints, where there really isn't a consensus on the number of points of match that have to be in order to constitute a match, to voice identification, to bullet lead analysis, where we're going to pretend that we can test the chemical composition and trace it all the way back to the not just the dealer but also the company where they sent it. Or my personal favorite, which would be laughable if it didn't have such serious implication, dog scent testimony, where an item would be given to the dog to smell, and then an item from the defendant, and if the dog barks, then that means there was a recognition. So it would be laughable, except that people were been convicted for several decades in Texas and Florida. So out of all those people that have been convicted by all these different junk sciences, blood typing, and even hair testing, and, you know, DNA testing in hair, yeah, mitochondrial DNA, that's legit, but to actually do hair comparison, these things are not scientific. There are no tables, there are no studies, there is no data to compare to say how many people out of a certain population would be capable of matching. Okay, so that's all junk science. It pretends to be scientific, but it's been denounced by the National Academy of Sciences. So when I think about all these different things, and I think about 13 people in 16 years that I did were exonerated either before me or after me, I come to my educated guess, and I keep in mind that the exonerations I mentioned to you are the people who made it out. That's not the people who are still in. So I personally believe that the percentage of wrongfully convicted prisoners is between 15 to 20%. But what causes these wrongful convictions? And what are their red flags? Definitely coerced false confessions have been the cause of wrongful convictions in 25% of the more than 300 DNA-proven wrongful convictions. where the reforms here would involve videotaping interrogations from beginning to end, from allowing false confession expert testimony into the courtroom so that the experts, they don't testify as to whether a particular confession is false or not, but instead they give contextual information to the jury. What are the factors that would lead an innocent person to confess? Having a pre-trial hearing before a confession could be used, where it's not simply looking at voluntariness. I mean, that hearing has failed us all miserably, but instead looking at whether a confession is accurate or not, kind of a confessional version of a Wade hearing. The red flags. What are the, no, I'm going to go to the reforms and I'll do the red flags. So, identification. Misidentification has been the cause of wrongful convictions in 75% of the cases. And what better identification procedures would involve a sequential lineup, looking at one at a time, ruling people in or out based on memory, not comparing to the other people in the lineup or in the photo array, making sure that everybody resembles the description given by a witness, recording the process, using the double blind method, taking a confidence statement on a scale of 1 to 10. How confident are you of your identification? Because in a case where everything turns on identification, by the time a trial rolls around, the witness would have been prepped several times by the prosecutor, testified a few times, and so the confidence level would have been artificially bolstered by that point. Having the double blind method so that the officer conducting that doesn't know who's suspected, so inadvertent or deliberate choosing clues can't happen. Telling a witness that an investigation will continue if an identification is not made, so that nobody feels pressure to make an identification lest the perpetrator escape justice. We need to have an external evidence corroboration requirement when it comes to the use of informants. So, incentivized witnessing, which is a synonym for snitch testimony, what I'm talking about now, that's been the cause of wrongful convictions in 15% of the cases. So it's important that nobody be arrested and convicted based only on an informant. There should be at least one piece of external evidence, because when people are caught red-handed committing serious crimes and they don't have truthful information to trade on, they will fabricate a story. They'll read about a case, they'll learn about a case, whether from the law book or in media, and craft a story and cut a deal. We need to have a standard factor of wrongful conviction. In fact, it's a factor that runs through almost all of the wrongful conviction cases. Most of us would be outraged if we knew that supposing we had been wrongfully convicted and did time in prison, but the prosecutor had withheld evidence of innocence, or they had coerced a witness, or they had threatened a mother to remove a child, or they threatened to charge somebody, or they withheld exculpatory material. If they did that and you served time in prison for a crime you're innocent of, you would expect that once you're exonerated, you would be able to sue that prosecutor, right? And you would have some accountability, but you would be wrong in thinking that. You would lose the case. You would be dismissed right away. You would not get to a trial because of the doctrine called prosecutorial immunity, which means that no matter how egregious the misconduct is, if it takes place after an arrest has been made, and the prosecutor is deemed to have done so as an advocate, and so they have that immunity. So I definitely advocate for removal of prosecutorial immunity. I think when those same type of tactics are engaged in, and that results in a wrongful conviction, and again, we're talking about clear-cut and intentional, not an accident, not a judgment call, not a good faith, but you know, intentional and clear. I think that in that situation, it should be criminalized. There should be a incarcerated penalty, the same way that when somebody commits a murder, they don't simply face criminal penalties, they can face a wrongful death suit also. Having a commission on prosecutor conduct, an oversight board, similar to the commission on judicial conduct, you know, a board that would be independent, that could have subpoena power and could investigate claims of misconduct. Because right now there's no oversight. You know, the bar associations, you know, they're not really equipped to deal with that. The Office of Professional Responsibility, that they're mainly looking at lawyers commingling funds and things that are not pertaining to prosecutorial immunity. So really, there's no one guarding the hen house, and the prosecutors like it just fine that way, thank you. But we need to have that commission anyway. It's the only job I can think of where they're actually above the law, and I don't see why we should have a class of citizens that way. You know, cops aren't given immunity. They're not chilled. They're not threatened, intimidated by lawsuits. They're not hindered from doing their jobs. They do a very simple thing if they don't want to be sued. They don't run over constitutional rights. Okay? They don't do things that cause a wrongful conviction. I think that this total lack of oversight in all the aspects, I mean, has led to prosecutorial misconduct really being a really rampant thing. We need a better system of public defense. Some of the there's built-in deficiencies that hinder even the most well-intentioned of defense attorneys. For example, it's not unusual for one public defender to represent 100 people at the same time. So you're law students like me. Imagine if you had to carry 10 classes. How good could your work be? But now I think you're doing 100, and it's cases of people's lives and freedom. Could you do your best? I don't think it's possible. There's an uneven economic playing field and manpower field between the prosecutor's office and the public defender's office. I think there should be the same amount of financial resources and manpower. And most of the time, the public defenders have to resort to asking the judge to allocate discretionary resources so they can hire experts and investigators. And most of the time, those requests are denied because the judges want to keep the cost of trials down on the county. I think that there should be one statewide system so there could be oversight and quality control, and so lawyers who engage in deficient representation aren't left in place to do so again. There should definitely be equal pay for both sides. But what are the red flags? As I get ready to wind this up, what are the red flags? The confession is false. Well, here are the red flags. If an officer is not asking open-ended questions where the suspect would fill in the details, where we can really see if they know non-public facts, but is instead being asked yes or no questions. If questions incorporate items pertaining to the crime, and then shortly after that, the suspect incorporates that into their statement, and that's a red flag. Certainly, youth and people with mental health issues, if that's present, then that's another red flag. If the external evidence is in opposition to confession. So I remember there was one case where the defendant said he broke into the side door, except that there was no side door. He said he killed the dog, except the dog died of dehydration. And he said that he abandoned the car in Delaware, except that the car was never found. And he said after he committed the crime, he took his girlfriend to the abortion clinic, except that the medical records show that incident happened a decade prior to that. So this is an example of that principle. When there's language that's above the life experience and educational experience of a suspect, that's also that's another red flag. If it's a co-defendant situation and the co-defendants are all telling a different story and getting the order of events incorrect, then that's another red flag. Police officers stopping somebody when interrogating them and correcting them, and let's take it again from the top. That's another red flag. In terms of misidentification, some of the red flags, that there have been people who have been wrongfully convicted, and despite the red flags, some of those red flags would be they've gotten race wrong. So there's been African American people who've been convicted when witnesses said it was somebody Latin. There's been Latinos convicted when the reports said that the perpetrator was black. We've had, like in William Lopez's case, for example, it was the perpetrators were Panamanian, except that Bill was light-skinned Puerto Rican, and they said 6'2", 6'3", except that Bill was a little bit less than 5'10". And they got his weight wrong, 100 pounds less. So significant height and weight inaccuracies is definitely another red flag. When it comes to informants, what are the red flags there? Well, a story that evolves, that keeps changing in its details, that's a red flag. If a informant seeks to lead law enforcement to an additional piece of evidence, except that when they bring them there, what they claim they're going to find isn't there, you know, absence of a murder weapon, that is another, that's another red flag. If there's a lack of another piece of external evidence, you know, that's another red flag. An informant being given a deal and then not being disclosed, that's a red flag, as well as their story not matching up to the external evidence. So, you know, my parting remarks here is that, you know, we're going to be lawyers, and there's different ways for us all to get involved. I believe that everybody should take on one case pro bono in your lifetime. You know, to free somebody wrongfully convicted. I don't think that it's asking too much. Definitely, you know, to do this type of work, you know, it unfortunately costs money. I mean, the people who do the work, they have to make a living, you know, and so it's not free to do these type of cases. So certainly donating something within one's ability from the salary, that's another way to get involved. Organizing events. If you happen to work at a future corporation that does corporate sponsorship, I mean, suggesting to them to give a donation to, you know, consider an entity that's working to do these type of cases. That's definitely a way to get involved. There's direct careers, whether you're going to be judge or if you're going to be an elected official, if you're going to be a staffer, bringing these issues up, that can make a big difference. In terms of steps right now, learning more about wrongful convictions, I mean, I think this is a great start. It's not the whole picture. Learning more about wrongful convictions, sharing that with your friends and family, that's really important. Contacting your elected officials, you know, every year for the last 10 years, you know, we can't seem to get any reforms passed in New York. We were on the precipice. We nearly got the Commission on Prosecutor Conduct passed. In Albany with many other advocates, and Professor Gershwin was right there on the front lines with us, and we came this close. You know, it was time to do a vote. You know, some of the prosecutors leaned on them and they got cold feet, and the electeds didn't feel like there was enough public support that they really wanted to do this. And so at the end, they never brought the bill up for a vote, although we were promised that they were going to give us the vote. So everybody contacted their elected officials and expressing that you want the Commission on Prosecutor Conduct passed, that you want interrogations to be videotaped, that you want better identification procedures. I mean, so long as they think that the status quo is sufficient, then nothing is going to change. There's a Patreon campaign which I'm doing in my foundation, and there's the website. So my dream is this. So I'll share with you. You know, I put several $1 million of my own money in. Okay, I can't carry the organization indefinitely on my own. This website is a crowdfunding website, and the idea is that it's not for somebody who wants to do a one-off donation. Okay, it's for somebody who is willing to sacrifice a cup of coffee a couple of times a month, or sacrifice eating out just one time, okay, to do a recurring monthly donation. My dream is to have 25,000 people who can afford to part with $3 or $5 on a recurring basis. We would be able to hire, as laid out there on that site, that's the website, we can hire several attorneys. We can hire 3 investigators. We can hire 3 paralegals. We can have an administrative assistant. We can have an executive director to run the show, because you know what, I'm not running anything. I'm here in law school, knee-deep in the books like all of us, because someone has to oversee. We need to have somebody who can their specialty is raising funds, and to have some money to hire, to have fundraising events. We would be able to work on many more cases than we can. We have 600 cases right now, a backlog, raw cases, not screened. There's only so much. We have a small staff. You know, we have 1 staff attorney, 1 investigator, 1 paralegal who doubles as an office manager. You know, we need to change that. So, in sharing with you my dream, it's not just to tell you about it. Okay, I need volunteers who, in one way or another way, let's make this thing go viral. However, nation and legality and ethics, beyond that, everything goes. You know, because it happened to me. It could happen to you, your best friend, your neighbor, your son, the student sitting next to you. Don't wait until you're personally affected. This happened to me. I was not a high school dropout. None of my friends were involved in crime. I was actually on my way to school when I was initially intercepted by the police. It happened to me, and it could happen to you. Thank you. So this is Wrongful Conviction Day, and as I said, I'm just one example. So super briefly, and then I'm going to be off. I want to recognize some other people knee-deep in the fight in reference to wrongful convictions. So our first exoneree, William Lopez, you know, he was in for 23 and a half years. I like to think that his next year and a half was the best year and a half of his life. And I like to think that because that's all he had. He passed after that. So, in attendance tonight is his widow, Alice Lopez. I just would ask her to just stand and face the audience for a second. Can we give her a hand, please? She stood by Bill for 19 years. She stood by him. I want to recognize a couple of mothers as well, whose sons are still incarcerated, and there's a general consensus that the people are innocent. In fact, even Professor Gershman has supported cases. I'd like to recognize first Doreen, who's the mother of John Jupa. You can stand, please, in the face as well. She went undercover. She lost weight, changed her hair, went undercover, all right, in order to speak with one of the jurors, and turned out that the last juror, his motivation for switching his vote was that he thought that Juka was Jewish because the name Juka, he was anti-Semitic, and he admitted to her on audio that was why he switched the vote. No shortage of evidence, you know, that's come up since then. You know, the informant admitting that he got a benefit in exchange for testimony, despite the prosecutor lying about that, and even saying, well, he has no motivation to lie, despite a second witness also coercing. The Juka case is a clear wrongful conviction case. Professor Gershman has written about it semi-extensively. And of course, we also have another example in Manhattan, the J.J. Velasquez case, where in that case we have several witnesses recanting the alternative suspect whose name appears in the early police reports as having committed the crime. Several civilian witnesses that this alternative suspect confessed to. Despite that, J.J. Velasquez was turned down by the fake sham Manhattan DA review unit, the appellate division. Then they went to the trial court with a post-conviction motion. That was turned down. They appealed that decision to the appellate division, simply asking for a chance to present that evidence, and that was turned down as well. So still fighting on behalf of her son and coming to a lot of wrongful conviction events and becoming an advocate kind of in her own right. I just want to acknowledge on Wrongful Conviction Day Maria Velasquez, who's here with us as well. All right, so I want to thank everybody, whatever you want to, any parting words or anything. But again, thank you for this opportunity tonight.
I just want to make sure everyone's aware and say thank you to the Criminal Justice Society, the National Lawyers Guild, PACE Chapter, and the Family Law Society for helping co-sponsor the event and put it on. And what did I say? Sorry, and I know we've gone a little bit over time. I know nobody really has left, and for good reason. They're listening to Jeffrey's story and others that everybody's just still here. So the room sort of needs to be vacated-ish, soon-ish, but I wanted there to be time to hear all of Jeffrey's story, and they have a couple of questions and answers if Professor Gershman's and Professor Mushland wouldn't mind staying to answer a few questions, because I know the audience has them.